So in preparing for this hearing today, I was prepared to listen for and hear anything that showed that there was a material change. As of right now, I don't see that there has been a material change. The only real change that has happened.
This right here is the legal backbone of the whole ruling. Material change. In bond hearings, judges aren't re-arguing the entire case. They're asking one narrow question. What's actually different since the last ruling? And already, you can hear where this is headed.
One is the court date changed, and then two, I don't believe I had the information in front of me that family members had signed contracts with different media companies at the prior hearing.
Notice how carefully the judge walks this line. This is crucial. She's separating emotion from legal analysis, saying, I believe you love your family member, but love doesn't cancel out risk. Judges do this to protect the record and prevent appeals based on bias.
So that's new material. When I look at this, when I asked the state and defense to come up when the witnesses were testifying, when defense objected to the line of questions that the state had, my concern was I wanted someone to ask or bring up the question of the veracity of these statements, because while I know, and I hope the family hears this, I'm not doubting your love for your granddaughter or your daughter.
This is where things get uncomfortable. Media contracts enter the picture, and suddenly, the court isn't just looking at family support anymore, but financial incentive. The judge isn't accusing anyone, but she is acknowledging how money and publicity can complicate risk assessments. What do you think? Should media deals matter in bond decisions?
There's Mr. DJ here. That's not in question. Okay, and I think I said this last year. So whatever ruling I make today, do not think that it is me determining your love and care for your daughter, right, or your granddaughter. With that said, I do have to consider some of the things that have changed, and with these type contracts, if she were to be released, y'all could benefit from your Ms. Williams actually used the term media frenzy. The more that's brought about, potentially the higher or more you as individuals would receive potentially. And so while that's not an IALA factor that I have to evaluate, that is some of the change that in consideration of where she's going, who she'd be with, and they play into the factors of.
Here's a reality check most people don't realize. A year and a half for a major felony trial? That's actually fast. TV has completely warped expectations. Judges think in terms of due process, expert reports, and fairness, not binge-watch pacing.
What could happen? But again, that does not play into whether or not you care or love your granddaughter or your daughter. All right. Going to the court dates. I don't believe that really goes into the material change argument, but it is a change in dates. And I want to lay this out. Ms. Patrick, I tried to take some time with you last time going through the arraignment process and going through the grand jury. So I'm going to lay this out for you today, okay? A typical criminal trial that most people don't realize, for that to be fast, for a criminal trial, especially one like this, a murder trial or a child molestation or rape trial, these heavy crimes, right? Most people in the judicial world would say that a year and a half is a really fast track for that case to be heard. And I'm sure your attorney's probably gone over this with you some. You're even shaking your head yes, like you understand that to be the case, right?
This part matters more than it sounds. The continuance wasn't a delay tactic. It was about fairness to both sides. Without full reports, the defense can't defend and the state can't prosecute. Ironically, rushing this case would have been grounds for appeal later.
So, right now, when your case first came up, the first court date that I gave you, I was trying to push because I know your age, right? And I wanted everybody to understand by me giving those first dates, do not drag your feet. But in all candor, if you remember, if you go back to that hearing when I set that date, kind of had a little caveat saying, I understand this may be pushing, right? And what happened was, as we came up, defense, you announced ready, but in actuality, you didn't even have your full report. And to do that, you would have needed that report. If we'd have started that day, you were thinking you might have the report by Friday, but you weren't sure. But I think you did what you had to do in the moment. Say you were ready, but you were announcing ready without the full report that you truly need. State needs that report. They need that full report to do their job and have their experts. So as both of you stated that day, and I believe the state even addressed here today, the continuance had to be given. The continuance had to be granted for fairness to take place, right? Fairness for you and your attorney to actually get the full report, and fairness for the state to be able to prepare for this case. Now, in doing that, I had a couple of different dates available. The state and defense both came to me and said, Judge, we know that you don't want to move this case again. We want to put it on your August date. That was the date that was agreed on by defense and the state. If I look at the dates, right now, we just acknowledged, and you were shaking your head yes, as if you understood, that a year and a half is really fast for these type cases. That's typically as quick as one will get, right? If I look at my dates now for your August date, you hit right at almost exactly a year and a half. So even with that August date, your case is still moving at an incredibly fast pace. You realize that? Now, with that being said, state and defense also know I do not want to continue this case again. Right? And we're going to do everything that I can. I'm going to do everything that I can to prevent this case from being moved again. Right? It's my understanding there may be some changes that take place. If those changes do take place, I do anticipate signing the order to specially set this. If there are conflicts, I commit to both state and defense. I don't mind calling other judges that may have conflicts and ask them if they don't mind if we jump ahead in line, so that I can have attorneys report to me so that we can make this happen. Right? And I hope that we can do that.
And there it is, the legal mic drop. The judge isn't saying nothing has changed. She's saying nothing has changed enough. In bond law, close doesn't count. Without a significant material shift, the original ruling stands. Bond denied.
But when I look at this again, I think the state's correct. I have to evaluate it for material change. I don't see much of a material change. The risks that were there at your first bond hearing still exist. I do have to say I can see both sides, but I do see from the state saying that things may be even intensified with these contracts, because that brings a whole level again of motivation. If you're out, what's going to motivate you or that side to do things? Because the more that's there, the more they have, the more potentially they get. That's a risk too. So based on that, and based on evidence that was given to me at the prior hearing, I believe any time that I make a ruling that takes into consideration statements that were made at prior rulings, I have to place that on the record. So I am placing on the record that part of this ruling is based upon the testimony that was given to me at the prior bond hearing. Okay, the statements that I heard then. And I'm not giving more weight to one side or the other. That's just not the case. What I am doing is properly weighing this to the best of my ability against the law. Right? And that's what I have to do with these factors. Right? Based on doing that, I am going to stand with the original order that I gave. Bond will continue to be denied. I do not find a significant material change in circumstances or facts that would allow or require me to make a change in that prior ruling. So the prior ruling will still stand. All right, your case is set for our August date. Attorneys, we will continue our meetings as we've done prior to this. I anticipate us still having our monthly conference calls to make sure that we can stay on pace and stay on track. If there's a change, please let me know if there's a change. And whenever that change is made, I will continue to bring that person in to continue with these monthly conference calls so we can keep this case on track. All right. I do want to say again, Ms. Williams, you and your staff and state, y'all have done fantastic job keeping me informed of this case and making it a priority. I greatly appreciate that. Y'all have both done a great job thus far, and I anticipate y'all doing the same moving forward. That'll be the rule of the court.